Yes, Mr. Appellant, may I apologise to everyone for us being a little late, first of all.
Not at all, my lady. My ladyship, your lordship, I appear today for the appellant, Mrs. Keegan, and my learned friend, Mr. Doyle, King's Counsel, appeals for the respondents, the liquidators of JDK Construction Limited, and the company itself. Just by way of housekeeping, can I just check that you've all had our skeletons and
Yes.
the authorities bundle?
We have, and if I can say, we've had an opportunity of brief discussion, and I can confirm that we've read all the skeleton arguments, obviously the judgment, and I think we've all dipped in quite substantially into the various authorities.
I'm most grateful,
So
thank you.
I'm conscious that this is listed for half a day, so I think we were all anxious to ensure we'd done all the reading for you.
I'm grateful, and with that in mind, I was going to adopt the following order. I'm going to show you the relatively small number of original documents. To the extent that that's not of assistance, I'm sure you'll cut me short and invite me to move on. That shouldn't take very long. Then I'll deal with the two grounds of appeal in order. Firstly, the section 127 point. Is the register of members conclusive, or is it simply prima facie on the point of who is a member, what shares do they have? And then the second ground of appeal relates to the status of a document that is either forged or is simply unsigned by the transferor. And what does that make? What difference, if any, does that make? And for ease of reference, I'm going to refer to the transfer and the liquidation throughout. I'm not going to say the purported transfer, that would be artificial, but I just highlight that. And so, by way of outline...
just before you,
yes.
you launch in, I wonder if you could just help us this. I mean, we are very conscious that whilst obviously there's a point of law which has permission to appeal has been granted, we're also conscious that this is not a family or a company where there is a very large amount of money involved, and we are slightly concerned about the level of litigation and what everyone is hoping to achieve by all of this.
It's not in evidence, and I can take instructions if you'd like further clarification, but my understanding is that it's understood by my clients, and in particular by Darren, who will become the controller of the company, that there is still value in this company, and his intention is to take it back, to sort out its liabilities and to take it forward. And so this is about him wanting his company back,
Right,
as I understand it. But as I say, that's not in evidence.
No. Well, I'm sure the liquidator, there's no objection to us being told that.
There isn't, my lady, but I wonder if I could just say my instructions are to contrary effect. My instructions from the liquidators are that...
Sorry, I'm about to be blinded. I think I better turn that off. Yes, your instructions.
Are that, is that Mrs. Jeanette Keegan is at pains to avoid the liquidation of a company in which her son was the protagonist in terms of management, and in which I am told there are a range of claims available to the liquidators against that individual. That's Darren.
All right.
And that if you like, the penny drops, or it becomes apparent what might be behind the application when one realises that there's a motive in seeking to frustrate.
Well, I don't think it's appropriate for us to then launch into those.
No.
There's sort of large evidential
I don't
issues
want
and
to get into
counter
that.
and cross-counter as to what
absolutely.
the motivation is. Just, we were concerned,
Yes.
as I think we should be when we're talking about what to the family is undoubtedly a huge amount of money, but in terms of company law and cases in the Court of Appeal and presence of leading counsel in such a modest assets case, we were concerned.
I'm grateful, Lady. My lady, following on from your question, it's my submission that, as the court's noted, the facts are unusual, and I say they're extreme, for the following reasons. The first one is that we have a purported transfer which leads to the liquidation of the company. So this document leads to the end of the company. That's in itself extreme. It's unusual that the person whose shares were transferred would have been unaware, but that's the evidence which is unchallenged. That too is unusual. The third unusual point is that filings at Companies House contain entries which on their face are inconsistent with one another and are inconsistent with the position as understood by the liquidators, because we've got the point about the additional person with the significant control, my lord.
You're going to have to
I'll take
show us to that. I think you should certainly show us that document.
I will.
And at some point, given the exchange that's just taken place with my lady about what people are hoping to get out of all this, I think I, for one, would like to know what's happened insofar as the Tomlin order is concerned and the working out of the Tomlin agreement.
I'm grateful, my lord. If I could turn my back for a minute to answer you on the Tomlin order.
Well, I think when we come to look at it,
yes.
if that's one of the documents you were going to take us to.
Yes, I was, yes.
Yeah, so perhaps just because I think that also feeds into some of the arguments that I think we're about to hear.
Yes, it does. Thank you. My lord, my ladies, the other extreme point, I say, is the delay on the part of the liquidators. And this is not a criticism of them, it's an observation that it is unusual for a liquidator whose validity of whose appointment is challenged to do nothing for a year before making the application to the court. And both parties' skeletons deal with policy. And so I say that's one of the issues that arises at my policy submissions at the end. So on that basis, I'll move on to the documents, which you'll find in the supplemental bundle. Thank you. So behind tab 1 at pages 3 to 4, one finds the application notice, which is undated but was issued by the court on the 6th of October 2022. And the relevant part for today is paragraph 1 at the bottom of page 3. And what's sought is a declaration that the applicant's appointment as joint liquidators of the company is valid. They were successful in that. Behind tab 2 at page 5, one finds Ms. Mayo's witness statement in support of her application. And as one would expect in these circumstances, the majority of the witness statement is a summary of the documents that follow to explain the chronology.
Yeah.
And the key documents, so picking up on my Lord Justice Snowden's point, if you could go to pages 6 to 7, one finds there at page 6 a summary of the background.
Sorry, did you say 67?
6 to 7, please.
Oh, yes, sorry. Yes, I have that.
And so over the page at 6E, Ms. Mayo's evidence correctly is that there were filings in respect of Mr. Lee Parker with a notice of individual person with significant control being lodged on 20th of April 2020, indicating that he held more than 25% but less than 50% of the shares. And then there's a confirmation statement on 13th of July 2020, which records Julie as the sole 100% shareholder. So that's my point about the inconsistent filings. It's the Lee Parker person of significant control.
What do you say? I mean, what legal relevance does that have?
None at all. It goes to the point that this is an outlier. That the liquidators are relying on the Companies House filings, which on their face look odd, because you've got somebody there shown as a person of significant control, but then being told that he's not a shareholder.
Okay, but this case turns on the status of the register of members, because this is a company where there is a register of members. This isn't a company which has adopted the new ability not to have a register of members and go by what's the Company's House.
Yes.
This case turns on the status of the register at the time
Exactly.
of the passing of the resolution to wind up.
Yes.
So I'm struggling to understand why a different document at Companies House has any legal significance.
Well, it goes to the policy point. It's not a particularly significant point. What I'm saying is that normally one would expect a liquidator who's relying on the Companies House records to infer what's on the register of members, because these liquidators have never seen the register of members, they've never had it, would at least ask a question when you've got an odd filing like that.
Okay, well, let's just start and make sure we're on the same page on that. There is a finding of fact by the judge that there was a register of members and it had a certain entries on it.
Yes.
And nobody is suggesting we go behind that on this appeal.
No.
So whatever else we might say about this document, as I understand it, it's an unusual situation because we don't actually have the registered members, but we have a finding of fact which isn't challenged by anybody.
Well, yes. And so, as I say, this is what makes this case an outlier on its facts. That you've got a register of members that the liquidators haven't seen. That's unusual.
Okay, but for the purposes of the appeal, we have to proceed on the basis there's an unchallenged finding of
Yes.
fact that basically that there is one and it says X, just as if it was sitting there in front of us all.
Exactly, yes.
Right, okay.
I'm grateful. I made the submission that liquidators didn't obtain a copy of the register of members. One finds that in statement at paragraph 13 on page 8. So, moving on to the key documents, if I may. First one, to show you for the sake of completeness, is page 23, where you find this company's Articles of Association. My learned friend, Mr. Doyle, and I mentioned this to one another briefly. The articles are in the bundle, the model articles aren't, and I don't think anything's likely to turn on that today, or to be a difficulty. At page 42, one finds the filing for Jeanette ceasing to be a person of significant control. The entry is with effect from 20th of April 2019, filed at Companies House on 31st of May 2019. At page 44, one finds the corresponding entry for Julie, where the dates are the same. Page 48, one finds the confirmation statement, also dated 31st of May 2019. And over the page at 49, one sees the transfer of shares from Jeanette to Julie. At 52, one sees the Lee Parker person of significant control entry, which never proceeded. He never became such a person, it seems. And then at 61, one finds the company voluntary liquidation document beginning. Page 61 is the notice filed at Companies House. Page 64 is a copy of the resolution to wind up and the resolution to appoint the joint liquidators. Page 66.
So, in terms of, I mean, I know you've been showing us what a member of the public would see at company's house. But in terms of the issues in the case, as I understand it, the only document that actually, apart from the foundation articles, the only document that actually has any legal consequences is the one you showed us at page 64.
Yes, that's correct.
Right.
Yes.
Together with the document which we don't have, but which
Yes.
we have a undisputed finding of fact.
Yes, that's correct.
Right.
Again, I'm simply showing you the relevant documents. But
Sorry, my questions are just so I'm sort of getting my bearings to make sure I'm
Yes.
in the right place.
these are simply by way of background, so you know what's in the bundle.
Yep.
At 68, one sees another document which perhaps goes to the questions from the bench earlier, which is the statement of affairs. That's signed electronically by Julie, dated the 8th of July 2021. And over the page, at page 69, one sees the assets, roughly £100,000. Over the page at 70, one sees the liabilities, and the estimated total deficiency as regards members is only £13,000 odd.
Sorry, I was, where were you? I missed that. I was just busy.
So if you go to 69, Milady,
Yep, I've got the
you'll
summary
see
of
the
assets. Yep.
Over the page at 70, one sees all the liabilities.
Yep.
The total liabilities in there are £97,751.95. That's 5 lines up from the bottom.
Yep.
And the total deficiency, of course excluding the cost of the liquidation, is estimated to be just under £14,000 at the bottom.
Yeah.
Which goes to this being a modest case, as the court
Wow.
has observed.
Yes. Well, the liquidator's costs will be significantly more than the deficiency.
Yes, and that is one of the issues in this case, because the liquidators have made it clear in their skeleton that they are concerned about getting paid. The last document to show you is page 70.
Do we have an up-to-date statement of the liquidator's costs?
I don't know if my little friends...
Do we have a number, even in ballpark terms?
Yes, I'm sure we can be given a ballpark figure.
Lord, we don't have a figure, but we'll get
We
one.
do.
Oh, we do.
We've got an estimated figure of our, in terms of our costs,
Yes.
are in the region of 40,000. But to date, nothing's been drawn.
I'll clarify what that is, my lord.
Very last document to show you, to put this into context, is page 73 of the same bundle and the same tab. And this is the letter from Mills and Reeve dated 13th of September 2021, putting the liquidators on notice that the validity of their appointment is challenged. Just showing you the documents, which I understand you've read, so I'll be very short. Behind tab 4, one finds Darren's witness statement.
Yeah.
The key paragraph is paragraph 6 at page 92. And then behind tab 5, one finds Jeanette's witness statement. And then at page 105...
Sorry, I missed that reference. Sorry.
Behind tab 5, there's Jeanette's witness statement, which I'm not going to take you to in detail, but it explains her background and the fact that she did not sign this document, which is not challenged now.
Yep.
And at page 105, one finds the stock transfer form. And so we know that the handwriting comes from the accountant at the top, because he says so, and that's in Miss Mayo's statement. And then there is a signature, J. Keegan, by the arrow saying, please sign here. And that signature it is common ground, was put there by Julie. That's her signature. And she says that she signed it believing herself to be signing something else. And as the learned judge said, she doesn't explain how she thought she then became the holder of the shares. The very last documents to take you to are Julie's defence in the rectification proceedings and the tomline order. And the defence begins at page 158. And the relevant paragraph is at page 163, and it's paragraph 12, subparagraph D. And there you'll see that Julie admits to signing the stock transfer form, but she says she did not do so with the intention of forging Jeanette's signature or any other person's. She intended to sign it as herself.
Sorry, you referred us to paragraph 12D.
12D.
D.
Yes. It begins, it is admitted
Yes.
that the first defendant.
Yes.
And so, 6 lines up from the bottom, her pleading is the first defendant, that's Julie, signed the stock transfer form on that basis, i.e. that 1, she was aggressively told to do so by Darren, 2, did not properly consider its contents and believed Darren when he told her it was an internal document that she was required to sign in order to end a disagreement between Darren and the claimant, and 3, she did not intend to forge and did not forge the signature of the claimant.
So, just going back in the bundle
Yeah.
to tab 10, where we see the particulars of claim to which this is a defence. Yeah.
Yes.
This is a rectification claim. Is it made under part? What is it? Part 7.
It was issued under Part 7, my lord, because I think rectification ought to be made under Part 8, but there is clearly a substantial dispute of fact.
Right. So, just looking at what was actually sought in the rectification claim, I mean, it was issued at a time when it was known that there was a disputed liquidation on foot.
Yes.
But the rectification claim didn't seek any consequential orders. It didn't join the liquidators, and it didn't seek any consequential orders as to what might flow. If you look at the relief that's sought, it's at page 153 and 154. It seeks declarations. Sorry, it seeks a declaration and then a rectification of the register, but nothing else.
That's correct, my lord. And the reason for that, if you go back firstly to page 153, you'll see that the liquidation is pleaded.
Yeah.
And the reason why it wasn't sought in this application is that the consequentials were to be dealt with by the trial judge having made his findings of fact and decision on the rectification point. Judge Hodge's first order adjourned the liquidator's application for directions off, and it was to be dealt with then.
So, is this right? I mean, this is something I want to come back to. Normally when you rectify a register, or when the court's asked to rectify a register, as I understand it, and I will be corrected, I hope, if I'm wrong, the court has the power to make consequential orders,
Yes.
or to give directions, for example, as to whether the register should be rectified with retrospective effect, and if so, what follows, and if not, what follows. And you're saying that that was agreed to be dealt with by the judge in the liquidator's application.
Well, look, yes, if you look at page 179, it's tab 15 of the same bundle that you've got there.
sorry, 159,
179.
179.
This is the order of His Honour Judge Hodge, King's Counsel, on 28th of October 2022, which is the first hearing of the Liquidators application. And one sees over the page at page 180 that there is the recital that Jeanette intends to make the application to rectify. And then there's the order adjourning this application, the Liquidators application, until the rectification application is dealt with by the judge.
See, at some point, I mean, I suppose my thinking at the moment a little bit, but something seems to have fallen between the cracks here. If it is right that the register should be rectified, if that was the claim, so as to put the register back into the form in which it would have been had the stock transfer form not been given effect to, because it was a forgery or false. The court would ordinarily have the power under that application to give directions as to the consequences, including the consequences for third parties, such as the liquidators.
Oh, yes.
But that's, as I understand it, conventionally it's done because that is a consequential matter upon the power to rectify the register.
Yes.
That didn't happen, as we're about to see, because the register has not been rectified.
That's right.
And yet the liquidators are, the court, Judge Hodge then proceeded to deal with a question as to what the status of the liquidation was, but on the basis that the register hadn't been has not been rectified, hadn't been and has not been rectified.
That's right, yes.
Okay. I'm just sort of putting it out there at the moment. I think we'll get a little bit further in this debate. But one of the consequences that I think your argument amounts to is that you say basically fraud, for want of a better expression, or forgery or invalidity of the transfer, call it what you will, should unravel all because
Yes.
it cannot be right. And yet the unravelling should, I would have thought, been done by the court as a consequence of an order for rectification, which just seems to have been completely bypassed.
My lord, it certainly could have been done, but it's my submission that's not the only way of doing it. I say that rectification is about correcting an error so that the register says what it should say. But the error in this case was of such nature that Jeanette was never the holder of 100 shares.
Well,
she was never entitled to vote them.
You say she was never entitled to be on the register of members.
Yes.
It's not the holder. People who pass special resolutions
Yes.
are the members.
Yes.
Doesn't say shareholders. It's a provision of the Companies Act which isn't in the bundle, I don't think. But it's the critical provision which deals with the passing of a special resolution. And that is the members pass the special resolution. I think the argument against you is that takes you back to what's on the register of members.
Yes, that's the argument against me. Yes.
And if that's valid, that's an end of the matter, unless or until you get rectification of the register. And if you get rectification of the register, it can be with retrospective effect, i.e. you get the register rectified, you get a declaration that the consequence is that the resolution appointing the liquidators was invalid. If it's appropriate to make that declaration, having regard to all the circumstances, including what's happened in the meantime. But none of that seems to have happened. I mean, I'll just put my sort of thoughts on the table at the moment.
Well, I'm most grateful, and I will address those. I could address those now, but I think it may be more useful to come back to them.
Take time to think about them and
Yes.
in your ordinary course of events. But since we were looking at the pleadings, it is odd that the rectification application by Part 7 doesn't actually seek any consequential orders, and as we're about to see, none were made.
Yes.
And what Judge Hodge has done is to say, I'll deal with the liquidators application once the rectification application has been done, but I'm not immediately. It's not immediately obvious to me what jurisdiction there is under the liquidators application to make orders consequent upon the rectification. Ergo, or especially in circumstances where there has been no rectification.
May I also add my tuppence worth, which is paragraph 19 of the particulars of the claim at page 153, which I think explains what the thinking was at the time, at least, and the way in which it was being dealt with. And it seems to me that it's implicit, perhaps, that it was considered that the alleged forgery meant that Jeanette had never been removed or Julie had never been inserted on the register, and therefore, by implication, that any rectification would be retrospective, in effect, although it doesn't say, and therefore all of these matters were intended to be dealt with then in relation to the liquidator and the liquidator's application. I'm not saying that's correct or incorrect, but that's just how I understand paragraph 19.
Yes, it's not my paragraph, but I understand the reading in the same way. And the point is that this is not a case where Jeanette was never a member. She was a member. She was a subscriber.
Yes, I'm sorry. Yeah.
And so she was always a member. And then the entry that we challenge is an entry removing her as a member.
Yes.
And we say that she was just never removed. And so the resolution was invalid because she was a member. She didn't receive notice. That's our challenge. But then we come back to the Tomlin order that I was asked to address you on, and you find that behind tab 14 at page 174. And the first two pages are the standard Tomlin order wording, and the schedule begins at page 176.
Yeah, this obviously post-dated the order. Yeah. Sorry, okay, that's fine.
Yes. And again, the schedule contains some perhaps slightly unusual wording, but the intention I submit is clear. At paragraph 1, there's an acknowledgement by Julie that she doesn't own Jeanette's previous 50 shares. Paragraph 2 contains an obligation on her to transfer the shares that she doesn't own.
Okay, hang on. Julie acknowledges she doesn't own the 50 shares. I.e., what's that? A sort of beneficial entitled. She's not beneficially entitled to them. So on the hypothesis we've got, she was registered as the legal owner of them.
Yes.
Okay, so okay, so we read it as sort of not entitled to.
Yes.
Doesn't own in the sense of isn't entitled to.
Or should it, again, you could read this in a number of ways. It could be that she's acknowledging that she's not entitled to be shown on the register as the holder of those shares, and that she's dealing with that by the pragmatic way of transferring the shares in paragraph 2. And then the...
So if pausing there, that if effect was given in some way to paragraph 1 and 2, the consequence is that Julie would have no interest in the company
Yes.
as a consequence.
And it's my understanding that that's happened, and that Julie has executed a stock transfer form, and you'll see over the page, at page 177.
How could that be given effect to without the consent of the liquidators?
I'm not saying it's been given effect to, my lord. I'm saying that she's executed the transfer form.
Oh, okay.
Again, my lord, you will notice that this is one of the oddities of this. Again, is that the liquidators are not a party to the schedule, to the Tomlin order, although the company is a party to the litigation.
And it can only act through its liquidators.
Yes, that's correct.
Except the Tomlin form recites that the parties have agreed.
Yes,
So that would, on the face of it, include the company.
it
no?
would.
So, so did the liquidators approve this on behalf of the company?
Were they given notice even of the proceedings?
I'm told the answers to that is no.
So who drafted this order?
It must have been my solicitors, because that says at page 175. Oh, I'm sorry, Julie's solicitors, I'm sorry. We signed it electronically, I think, and served it.
So was it served on the liquidators?
It was, my lord, it was served after it had been executed. But what may assist is the order that was made on the 28th of October, page 179, had stayed the liquidation. It's paragraph 2 on page 180. I'm not sure staying the liquidation would actually get round the problem, but I just mention it.
I don't think it would.
But the liquidators were not asked to sign it.
Yes. Well, if the liquidation was stayed, in a sense, the court then is telling them don't do anything.
Yes.
Okay. Oddity heaped upon oddity. Right. Okay. Fair enough.
But in any event, the Tomlin order is sealed on the 19th of June,
Yes.
well before the order that Mr. Doyle's just taken us to stay.
No, no, that was the point I almost made. It's a different year. The order was 2022. The stay was in 2022, October 2022.
Is it?
Yes.
Yeah, and
Oh, yes.
yeah. Sorry, that's the mistake.
Beg your pardon.
I almost said that myself.
Oh, well, there we are. I was one that put my foot in the trap.
Just for completeness, I was asked about other provisions in the Tomlin order. If you go to page 177, you see that Darren has agreed to pay an ex gratia contribution of £8,000 plus VAT to Julie for her costs. That's being paid, I'm told.
It's quite curious, isn't it, that in a situation where there is an extant liquidation, or at least arguably an extant liquidation, that it should be agreed between the parties, which ostensibly includes the company, but otherwise, that the following assets, insofar as they are in possession of the second defendant, which is the company, belong and should be retained by Julie. You'd have thought that on the face of it, the liquidators might have something to say about that, at least to say, yes, that's fine. The company doesn't own those assets, even though the company is in possession of them.
Yes.
And there's actual reference to Janet Mayo in 3.1.
Yes, that's right.
Anyway,
And Because Janet Mayo is being referred to as a liquidator in the Liquidators, and this doesn't seem to be signed because it's done electronically, it's not before the court today, and I don't think anybody can take it to its final conclusion, but it may well be that this schedule has only two parties, three parties, Julie, Darren and Jeanette.
So, see, the curiosity, going back to paragraph 1, is that at this stage, had the issue been properly ventilated, at least between the parties, as to what the status of the register of members was? I assume, in a sense, it had, hadn't it?
Yes, in the sense that there'd been a particulars of claim and a defence.
Yeah. So everybody knows, at least on the face of it, the suggestion is that Julie is on the register of members in respect to the 50 shares referred to in paragraph 1. She acknowledges she doesn't own them, but nobody does anything about actually rectifying the register of members.
Yes.
Even though that's the whole purpose of this claim.
Again, I'll come back onto the point that it's about Jeanette being wrongfully removed, but yes, I do accept that it's odd that this was not dealt with in this document.
Yeah.
I'm not sure I can take it very much further.
Okay.
And paragraphs 8 and 9 of the tomline order, which are the full and final settlement and the agreement not to sue, all relate specifically to each other in the sense, presumably, of Darren and Julie in relation to matters arising or connected with the company, which gives some weight to your suggestion that actually this is between those parties.
Yes, thank you, Maddie. Those were the contemporaneous documents I intended to take you to. Unless there's anything else that I can assist with,
No, that's been most
I'll move on to
helpful,
the
thank you.
submissions. I think it's unlikely that we'll need to look at the supplementary bundle again during my submissions.
Thank you.
So perhaps I could take you to Judge Hodgkin's counsel's judgment, which you find at tab 8 of the main book, page 65. Paragraphs 1 to 8 are some of the facts that we've just looked at. And paragraphs 9 to 11 are Judge Hodge's finding of fact that the register of members duly recorded a transfer of 50 shares from Jeanette to Julie, such that Jeanette ceased to be a member on the face of the register. No challenge is made to that finding of fact, of course. Over the page, we've been looking at previous features of this case. At paragraph 15 of the judgment, Judge Hodge notes the curious feature that Jeanette describes herself as a former director and apparently accepts that she ceased to be a director, but doesn't explain how that was terminated at the same time as this disputed share transfer.
Well, again, in a sense, that's just a factual step en route to a conclusion that that Jeanette actually, yeah, I'm not sure where that takes you. Actually,
It doesn't take me anywhere.
no.
I was observing it as part of the factual matrix.
Yeah. Okay.
At paragraph 16.
It's just yet another fact of the type that is put into a moot to make life even more difficult.
Yes. And back to my initial submission that the facts of this case are outliers. I hope I've made that submission good in some way. One sees then at paragraph 16 Judge Hodge's understanding of the orders that we looked at staying the liquidation in anticipation of a finding as to an allegation of forgery and that not happening. Paragraph 20 is a summary.
Actually, he describes it as a Part 8 claim form.
Yeah,
Yes.
I wanted it was part 7.
It's Part 7, isn't it?
It was Part 7. The practice direction says Part 8. We issued under Part 7 because we thought there was going to be an almighty dispute.
Which is correct.
Yes. Yeah.
Yeah, I mean, that is the correct way to do it.
Yes.
I mean, often these things are done under Part 8 because it's not anticipated there'll be
Exactly.
a dispute, it's just an error.
Yes.
And the reason that the court gets involved is because people shouldn't generally go around rectifying registers just on their own because of the consequences.
Yes.
But where there is a substantial dispute, you do it by Part 7, so yeah.
The judgment then deals with the facts and the build-up to the current that hearing, and then we pick up again at paragraph 31. Where the judge records my submission before him that nothing was to be gained by any further investigation of the evidence, because there's no suggestion that Jeanette has in any way authorised the forging of a signature, or that she's acquiesced in the transfer, or is stopped from denying that it's a forgery. My learned friend Skeleton takes the point that this was a submission that was not wholly accepted by Mr. Cochrane in the court below, but my submission, nothing turns on that. The judge then summarises...
Well, no, nothing turns on it because the judge accepted your submission.
Yes.
So the fact that the other side made a counter submission doesn't take matters any further at all.
And so one then goes on to page 48, so paragraph 48, page 75. Actually, if I could invite you to go back to paragraph 46 first. The judge accepted my submission that if the purported transfer of the shares from Jeanette to Julie was ineffective, and for as long as Jeanette remained the holder of those shares, and that remains my case, then because she wasn't given notice of the EGM, then the resolution to liquidate was invalid.
What does he mean?
I'm sorry, my lord.
What does he mean by that? Why? What does he? I mean, sorry. Let me be specific. Why is he talking about? What does remaining the holder of the shares mean?
My lord, I think Judge Hodge may have been falling into the same linguistic error that I did earlier and that your lordship corrected me on. He must mean member because that's what the Companies Act says.
But the problem with that, and this is where the issue, this is why it matters, is that he has at paragraph 11 approached the application on the basis that at all times, and particularly at the time of the resolution for voluntary winding up, that Julie was showed as the sole, well, he says shareholder, but it should be sole member.
My lord, it's my submission that the fact that Jeanette's name had been removed did not mean that she had ceased to be a member. It means that she is still a member. She still has all the contractual rights that arise by nature of the statutory contract between the company, its members, and the members themselves, and that the change to the register is of no effect.
Right. So, so where was the submission? Does he record the submission that he then that he is accepted? Does he elsewhere record it? That your submission, as I understand it, therefore, is that somebody who is not entered on the register as a member is nevertheless a member.
My submission is that to become a member, you have to be entered on the register.
You have to agree and be entered on the register. Yeah.
So that's unless you're a subscriber when it's different.
Yep.
You're automatically a member, even if you're not recorded on the register. That's what Section 112 does.
If you're a subscriber.
Yes.
Yes.
And what I say is that if you're a member and somebody removes you as a member, you still are a member if that removal is invalid.
Wait a minute. Okay, so let me go back a little bit. Jeanette's a subscriber, is she?
Yes.
So does your argument depend upon that fact?
No, but it does, because I say that that really goes to the point about section.
So why do you say it doesn't?
Well, no, I'm thinking it through. My primary case is that it doesn't, because if you're a member and an invalid stock transfer form comes in that's either forged or is unsigned by the transferor, and directors with knowledge of that fact take your name off the register, you're still a member. That's my primary case.
Right. I understand that's your primary case.
My alternative case on the subscriber point is that subscribers don't have to be recorded on the register of members to be members. They are automatically a member.
You're going to have to show us this. And
Yes.
is Jeanette, or was Jeanette a subscriber in respect of 50 shares, or just one?
Can I show you the subscription now before I get my... She was in fact a subscriber for 100 shares, and she transferred 50 to Jeanette, to Julie.
Okay, so the greater would include the lesser then.
Yeah, so if you go back, I'm sorry, to the supplementary bundle, and at page 16, behind tab 3, one finds the application to register the company.
Yeah, it's not page 19, isn't it?
Yes.
I think there's a decision, strange enough, I think of this court on appeal from Judge Hodge last year or the year before, dealing with, actually was it from Judge Hodge? But anyway, that is evidence as to the subscriber or the subscribers, but normally the subscribers are the people who sign.
You find that on page 21, my lord.
Yeah, there we go.
There he is.
That's it. Yep. And they take it. I think the consequence of the decision is sort of is that although that refers to at least one share, oh crikey, I'll have to go back and remember it because it actually mattered as to whether you're only a subscriber for one share or whether you read the two together and you become a subscriber or as to 100 shares. And I think the answer, from memory, the answer was the latter.
I think as well, and I'll need to check.
But,
I forgot. I remember the case, but I forget the name.
Likewise, it's because this is the old form before electronic days actually did literally have a signed undertaking to take shares. But okay, anyway, but at least right, okay. Right, okay. This is getting,
We were looking at the judge's judgment.
Yes.
yeah.
Have we finished with 46? Are we
Yes,
moving
we
on to
have
48
finished
now?
that, yes.
Yeah.
Thank you.
.47, back on page 74. So you don't need to look at 47. 48 is the judge's identification of what he says the real issue in the case is. Whether even on the footing that share transfer form was a forgery, Jeanette should have been treated as a member of the company for the purposes of the requirement to participate in the special resolution to place the company into winding up. It therefore seems to me that the real issue in the present case becomes one as to Jeanette's continuing status as a member when, on the evidence based on the filings at Companies House, her name did not at that time appear on the company's register of members. Paragraph 49, the judge decides that section 127 is conclusive as to those who are members of the company at the time of the special resolution. And he says section 112 subsection 2 is clear. The person whose name is entered in the company's register of members is a member of the company. Since that's reinforced by section 125, which we'll come on to. And then at paragraph 50, he says that the scheme of the Companies Act is that the register is conclusive as to those who are members of the company at any particular point in time. So even if the register of members were liable to be rectified, then the company was nevertheless validly placed into winding up. So having looked at the judgment, I'll move on, if I may, to my first ground of appeal, which is the interaction of sections 112 and 127. And you'll find section 112 in the authorities bundle at page 5. I've alluded to this already. Section 112 in my submission creates two distinct regimes for members. Subsection 1, if you're a subscriber, you become a member. It's obligatory that you be entered in the register of members, but if the directors, for whatever reason, do not comply with that requirement, a subscriber remains a member. And then subsection 2 deals with becoming a member, not ceasing to be a member, but in order to become a member, you must agree to become a member and your name must go in the register. So there are two distinct categories for these purposes. My lord and my ladies, if we could go on to section 113, which is on page 6. This is important because it tells us what the register of members must include. And so we see at subsection 1, every company must keep a register of its members. And at subsection 2, 3 things have to be recorded for all companies: name and address of the members, the date on which a person is registered as a member, and the date on which they cease to be registered. And then in subsection 3, 3 more things are required for companies with a share capital, which is share numbers, share class, and the amount paid or agreed to be paid. And the remainder of that section deals with stocks and then with offences for non-compliance. Section 114 is in the bundle. It just deals with inspection. And if we could go on then to section 125, which deals with rectification, and that's page 14. And paragraph 1 gives the court the power to rectify the register of members at section 1A if it does not include information that it is required to include. So on my submission, that gives the court the power to rectify the register if a subscriber who is a member is not shown as being a member. And the purpose of that is obvious. It's clearly desirable that the register should be correct. And subsection 3 of this provision gives the court the power to deal with questions relating to title. So this is a mechanism by which a person's standing and right to be a member may be litigated. And so then if we jump on to section 127 at page 15,
And lastly, at the end of subparagraph 3, and generally may decide any question necessary or expedient to be decided for rectification of the register.
Yes.
Which also may include retrospectivity.
Yes, anything at all, yes.
So,
I'm grateful.
Factual phrase.
And then at 127, one sees the provision about prima facie evidence. And it says the register of members is prima facie evidence of any matters which are by this Act directed or authorised to be inserted in it, except for matters which the Central Register is prima facie evidence. The words in square brackets don't affect us on this appeal. So my submissions on section 127 are relatively short. First one is that the language used in section 127 is clear. It says any matters which are by this Act directed or authorised to be inserted in it. I say that the natural and ordinary meaning of those words is that all of those matters which are set out in section 113 are prima facie evidence, but no more. There is no distinction between the different categories and the different sub-aspects.
hang on, wait a minute. What? I don't follow. Why are you focusing on 113? Why aren't you just saying she's a subscriber?
Yes.
She's a member. Section 1121 says that she must be entered as such on its registers of members. I don't understand the detour through 113.
Well, His Honour Judge Hodge made a finding of fact that there would have been a transfer from Jeanette to Julie, because Jeanette always was a member. She was the only original member.
Yes,
Then Julie comes in and they're 50-50,
correct.
and then Jeanette goes on their case.
Yes.
But we say she doesn't. So the transaction that I'm challenging is the recording of Jeanette ceasing to be a member.
Yes.
So she always was a subscriber, and we'll assume, as her Judge Hodge did, that the Register of Members recorded Jeanette as the member because it would have to record the transfer from Jeanette to Julie that's being relied upon to show Julie as the 100% shareholder.
Okay.
Sorry.
Jeanette is a subscriber.
Yes.
For 100 shares.
Yes.
On the face of it, section 112.1 says she must be entered as such on the register of members. So let's assume that was done.
Yes.
She becomes a member.
Yes.
At some point, 50 shares are transferred lawfully.
Yes.
So at that stage, Julie 50, Jeanette 50?
50-50, yes.
Yeah, 50, sorry, 50-50.
Yes.
Right. You say there's then an invalid removal of Jeanette as a member.
Yes.
Because her name on this hypothesis is struck out of the register.
Yes. And Julie is shown as having more shares.
So you say the register of members is prima facie evidence of matters which are by this Act directed or authorised to be inserted in it. It might be said, well, it's prima facie evidence, but only prima facie evidence that the 50 shares in Jeanette's name were transferred.
That's my case. Because Judge Hodge has said that it's conclusive. What's on the register of members is conclusive.
Does it make a does it make a difference? I go back to a question I asked you a little earlier. Does the answer to this analysis make a difference as to whether the person is a subscriber who, on the face of it, is entitled to be on the register in respect to the 50 shares, in fact 100 including the 50, or not?
My primary case is that it doesn't make a difference, because what we're focusing on is the very narrow single entry of the transfer of the second transfer of 50 shares from Jeanette to Julie, leaving Jeanette with 0. That's the entry in the register that is under challenge. So if we assume that the previous entries were correct, as Judge Hodge did, then at that date, I forget the date in April 2019, I think it was, Julie and Jeanette were shown as 50-50. There's then an entry which shows Jeanette 0, Julie 100. And we say that's invalid. It doesn't matter how they got to the 50-50, whether that's by virtue of Jeanette being a subscriber or by virtue of her being a member, because the register was correct up to that point. My second point, it comes out from what's just passed between me and the bench, so I'll be very short, is that Judge Hodge must be wrong to say that the register can be conclusive as to who the members are, because that overlooks the position of subscribers. So it's my case that we can go behind what the Register of Members says, and that leads us on to the second round of appeal.
Just before you go on
Yes.
to there, as a non-company lawyer, going back to section 112, the Lord's point about the difference between subscribers and non-subscribers. Is there any significance, do you say, in the fact that so far as subscribers are concerned, they're deemed to become members, whereas everyone else has to agree to become a member, and presumably you can't agree to become a member if you've got a fraudulent forged stock transfer form?
You certainly can't agree lawfully. If I'm a party to the forgery and I want to become a member, well, I can agree to become a member on the back of a forgery, but that must be unlawful.
Yes, well, I was using
Yes.
shorthand.
Yes.
Well, does that difference take us anywhere in your analysis?
In my analysis, no, because what we're looking at is the narrow point that before the stock transfer form that was not properly signed, the register was correct. It showed these two people as being 50-50. And so what you're looking at is the entry changing the 50-50 to 100 and 0. But the only relevance of section 1121 in my submission is that it shows that the register of members can't be conclusive, because if a subscriber is omitted, they are a member, whatever the register says.
That's why I asked you whether it made a difference.
Yes.
That's exactly, yes.
Yes. But you see, if you've got suppose you've got a subscriber who is shown as being on the register, that they've got it right, as they did in this case. So I'm a subscriber for 50 shares. My name's on the register. A forged stock transfer form goes in and I cease to be a member. I don't think, in my submission, section 1121 doesn't seem to say that the status of subscriber goes any further than that initial entry.
I mean, could it be said that the way you deal with this, section 127 just says the register is prima facie evidence. And let's rewind. If you have a subscriber who does transfer their shares
Yes.
away validly, they will cease to be shown as a member on the register of members.
Yes.
And so you'd say the status of the register at that stage, prima facie, is evidence that although they were a subscriber, were a member, that they have validly ceased to be
Yes.
a member,
That's exactly how I put it, yes.
in the same way as anybody else who is a member at some point because they come in under section 112.2 and
Yes.
they transfer the shares away. So it's prima facie evidence when you look at the register and you don't see them that they, through one or other route, have ceased to be a member.
Yes.
Because you plainly can cease to be a member if you are a subscriber.
Yes, that's right.
So why is it that if you say you've got a forged stock transfer which results in the subscriber being taken off, that the register isn't any longer evidence of that? I mean, I'm struggling to understand. Or your submission seems to be sub silentio that something which is forged is a nullity.
What I'm saying is that the register is only prima facie evidence. It can be disproved. The register, the document, is evidence of the matters recorded on it.
Yes.
So there is a matter recorded on this register of members, which is a transfer of 50 shares from Jeanette to Julie.
So you're saying what the judge should have done is to say it's only prima facie evidence, and I have just been given, or I've just decided in my judgment, that in fact there was no valid stock transfer, ergo I should give effect to that,
Yes.
and you say he should have declared that Jeanette remained. This is where I find it difficult. That he should have declared that she remained a member.
Yes.
Even though she wasn't entered on the register.
She was wrongly removed from the register. Yes.
And that's
where the deemed comes in.
That's where the difference between the subscriber and somebody else comes in, because,
Well,
or possibly.
well, I'm not sure that is your submission.
Oh, sorry.
So I'd like to clarify that, because I think that what you're saying. Sorry. Because I think that what you're relying on section 112, subsection 1, as I understand it, to just show that in fact you can be a member if you are a subscriber, because you're deemed to have agreed and you must be entered in the register. And you're saying, I think, on the basis of that subsection, even if you haven't been, section 112.1 makes you a member as a subscriber, and you're using that to cast a shadow, put it that way, on 127 to say, there's an example of somebody, it's only prima facie evidence because you may not have been entered in the register, but 112 subsection 1 says because you're a subscriber, you are a member.
Yes.
So you're using that as an example of where you may be a member, but for some reason, and we're not looking at forgery or anything else, you might not have been entered on the register, and therefore it's only prima facie evidence under 127, but you still are a member under 1121.
Yes.
That's how I understood what you were saying. But you were not going back to say, I'm relying on the fact that Jeanette originally was a subscriber and you can't wash that out. You're not making that distinction.
That's correct. I'm not relying. What I'm accepting on the basis of Judge Hodge's findings is that before the impugned stock transfer form, the register of members was correct. It showed each lady is holding 50 shares each. And so what am I objecting to? What's wrong? The answer is the entry at that stage, removing Jeanette's remaining 50 shares.
Yep.
The reason I'm labouring this point is paragraph 49 of Judge Hodge's judgment, because he found against me on the section 127 point.
Because he says it's conclusive, and
Yes.
you say
And
that's not what it says.
I say it's not.
Now, I understand the conclusive and prima facie point, but I'm still niggled away by that there is a difference between somebody who comes to a company after the subscribers, because they don't have the status of member until their name is entered on the register of members. That's one of the twin requirements in section 112.2.
Yes.
So even if, as it were, they were wrongly taken off, until you rectify and get them actually put back on, The argument is they are not members because they just don't qualify as under section 112.2. And I know you don't agree with that, but that's the argument against you, that you have to have rectification in relation to somebody who comes to a company after the initial subscription. And unless or until you do get rectification and they go back, they are put back on the register, they are not members. And that's why rectification exists as a power and all the other things that go with it. But the reason I was thinking that it might make a difference is because with a subscriber, even before rectification, and in this case it may make a difference because there has been no rectification, the court could say, well, because the register is only prima facie evidence, because I've made a finding that the person should not have been taken off because the stock transfer form was not valid, they can still be a member because they happen to have been a subscriber, because they are given that status irrespective of whether they appear on the register by section 112.1. And if that's right, then this resolution wasn't passed by the members, but all of the, by a requisite proportion of the members. So that's why I know it's not your primary case,
Yes.
but it seems to me it might actually make a difference that Jeanette was a subscriber.
It's not a point I thought of until I came into court today. And
that's the benefit of all argument one way or another.
I'm thinking on my feet, but I certainly do see
well,
the merit in it. Obviously.
Until Mr. Doyle stands up, doubtless.
Yes.
But Mr. Doyle, as were in a sense, has heard the point. But it's a pure point of law.
It is, yes.
As I see it, but it's another wrinkle in this case.
Yes. She was always deemed to be a member. The difficulty arguing against myself.
The difference is it doesn't matter that you, in her case, that you didn't actually get an order to rectify. That's at least, I'm not saying that's right, I'm just saying that seems to me to be a potential argument.
Yes.
Whereas if this argument had been taking place and she wasn't a subscriber, Mr. Doyle's argument is, look, the register is the register is the register, and you just can't be a member unless or until the rectification takes place and you're put on it.
The point I would come back to on Mr. Doyle's point on that is looking at what section 112 actually deals with. Every other person who agrees to become a member of the company and whose name is entered on its register of members is a member of the company. And the question then is, what does "is" mean? Does that mean that's your test for becoming a member? Or does that mean that if you are taken off the register, you cease to be a member, even if you're taken off wrongly?
Well, the problem with this is that companies generally have to function in the real world, and they have to function by reference to knowing who their members are, because you need to know who to give notice to and who to votes to record. And if you have people who are members who aren't on the register, won't the system just break down? How does it work where you've got these unknown members? Surely the whole point of a register is that it gives the one point of reference for a company that actually is vital, that the company can act in accordance with. Because otherwise the whole system of company law just breaks down if you have sort of these random people who are actually members but you don't know about them because they're not on the register.
Well, as I say, the facts here are outliers, but you've got a director who's changed the register here.
Yeah.
And this is not the electronic register regime that's now in place,
No.
which is different. This is the old regime.
Yeah.
So you've got a director who's in place who's altered the register with no justification at all.
Correct.
And on any view in breach of duty. Either there's a forgery or she's altered the register of members on the basis of a document that she thought did something else.
Yep.
So in that situation, yes, that gives the possibility of uncertainty, but it's only uncertainty where you've got a director acting in a breach of duty like that. And the consequence
Could be all sorts of things. I mean, somebody could. In fact, we had a case not very long ago in this court, a couple of weeks ago. Somebody forges the stock transfer form and submits it to the company for registration. The director absolutely innocently and in perfect good faith doesn't realise it's a forgery and gives effect to it in the register of members, and the shares are transferred to the fraudster. If that's right, is this right? You're saying that the fraudster doesn't become the member when they're written into the register as the member for the purposes of the company, and if so, why not?
Well, the facts are completely different, because in your lordship's example, the director is completely innocent. In our case, the director is either a forger or is in breach of duty by processing a document which he knows to be wrong. That's the difference.
But from the perspective of status of a member, when you look at section 127, it says that the register, in whatever form it is prima facie evidence of those who are entitled to be on it.
And so the words prima facie in my submission must open the door to that prima facie assumption being rebutted. Because if the legislature had intended it to be conclusive, it would have said conclusive, not prima facie. And prima facie, the language of prima facie is used in the context of share certificates at page, that's section 768 of the bundle, the authorities.
Sorry, page?
I'm looking, it's section 768, it's page 19.
Yeah, I've got it, thank you.
Exactly the same language is used for share certificates. It's my submission that the clear intention of the legislature is that that evidence can be rebutted. The onus is on the person seeking to rebut it.
Now, Mr. Fennell,
I'm very conscious of time.
conscious of time, but it's not at all your fault. You've been bombarded with questions from the bench.
I think I've moved on to my second round of appeal.
Yes.
Which is dealing with, but if you accept that the register is not always conclusive as to who is a member and who is entitled to vote, then the question then becomes, what's the effect of this stock transfer form? And I've got relatively little to say in addition to what's in the cases. So what's in my skeleton? You're familiar, my ladyships and my lordship, with Reuben. You find that at page 31 of the document, of the bundle, I'm sorry. And the facts are stated in Lord Lawburn's judgment at page 34.
For some reason I don't have page 34 in my bundle. Sorry, that's just a... Basically, sorry, it's before page 39. Rather bizarre.
Of course it is.
Sorry. Yep.
It's probably quicker if I just invite your lordships quickly to read the paragraph beginning, "The question arises," which sets all the facts out very clearly. here we've got a forged stock transfer form. The company doesn't register the holders on the back of it. They sue for damages. And one sees the reasoning of the House of Lords beginning at page 443. Lord Lawburn at the top in the paragraph that's highlighted. The forged certificate is a pure nullity. Quite true that persons dealing with limited liability companies are not bound to inquire into their indoor management and not be affected by irregularities of which they had no notice. But this doctrine, which is all well established, applies only to irregularities that otherwise might affect a genuine transaction. It cannot apply to a forgery. And then the judgment goes on to deal with estoppel. Lord McNaughton says something very similar on page 36.
He's pretty robust.
Yes.
I don't think we'll be saying to you that your submissions are made with much ingenuity but are absurd.
One sees then at page 36, Lord McNaughton in the highlighted paragraph is equally robust. And then perhaps the most robust statement of the lot is at page 37, Lord Davy. My lord, to use the language of a distinguished judge of the last generation, the appellant's case seems to me as full of holes as a colander. There's not a step in their title which is not tainted with fraud going to the root of it. And then finally, at page 39 of the bundle, one sees the highlighted section from Lord James, observing that this is one of the cases in which it is said that one of two innocent persons must suffer. And then he talks about the transferee having a safeguard. A company cannot protect itself against the frauds of its secretary. And if the company has to bear the burden of this loss, the placed upon companies will be very great, and there is guard against it. And he says that somebody can make inquiry of the directors. Well, in my submission on this particular case, that's the answer. And that's the answer to the policy point that my learned friend raises, page 104 of the bundle in his skeleton. It says that third parties can do nothing to safeguard themselves from the risk here of accepting appointment as liquidator when the director hasn't passed the necessary resolution. Well, liquidators can protect themselves. They can take an indemnity from the director. They can take a warranty from the director that the register of members is properly constituted and that the necessary people have been given notice. That's the liquidator's protection.
I mean, on the facts of this case, intriguing though they are, Reuben, are a million miles from our case, in the sense that Reuben was all about somebody forging a stock certificate, a share certificate, which is only evidence of title.
Yes.
And using it to perpetrate a fraud on a third party who undoubtedly looked around for somebody to recover from and attempted to recover from the company on the basis that the company must be bound by the fraudulent act of the secretary, Reuben. And the court said, no, it's got nothing to do with the company. This is just a fraudster off on a frolic. There was nothing connecting. He just created a document which had nothing to do with the company. You can't make the company liable. And that's what this case is about, isn't it? I mean, it doesn't actually have anything to do with title to shares or anything like it. So I'm struggling at the moment to understand what we get from it.
Well, it's the ratio in my submission of Reuben is that a forgery is a nullity. This is the foundation of that principle. Now, Jeanette has been deprived of her right to vote on the liquidation by a document which was either a forgery or, on Julie's very best case, was not a transfer at all.
Yes, but the document itself is a stock transfer form, which is
Yes.
never a document of the company. It's always just a document of the transferor.
Yes.
That's what a stock transfer form is.
Yes.
It's never going to be a document of the company.
And so, it's not. It's a document of Jeanette. Jeanette has been removed from the register of members on the basis of, in our case, a forgery.
Yeah.
The director is on notice of that forgery. She did it herself. And if she's innocent, then she's completely misunderstood what the document is and forgotten that she's only the holder of 50 shares. In that situation, does Jeanette lose her rights as a member? Does she cease to be a member of that company because the director has forged or wrongly forged a stock transfer form and wrongly altered the register of members?
Well, are you saying that you do attribute that knowledge to the company, or you don't?
Well, we have to, because Julie is the company's sole director. Darren isn't a director. Julie is the sole director, and she deals with this stock transfer form and causes the register of members to be changed. This is distinct from the case your lordship gave of an innocent director being hoodwinked. This is a director wrongly and in breach of duty.
But there are some really difficult cases about the circumstances in which a company is bound by the acts of particularly a one-person company.
Yes.
None of which we have in the bundles.
My lord, we don't have them in front of us, but I don't understand it to be a controversial proposition that where a company has a single director, and that director is has knowledge of the circumstances leading, say, to the stock transfer form, that knowledge has to be imputed to the company.
Well, but there are a whole raft of cases going right up to Supreme Court that say it's a really difficult question about when a company is bound such that liquidators, for example, can't pursue a cause of action against the single director wrongdoer.
That's a slightly different point, my lord. With respect, that goes to things like the illegality defence, and I've got in mind Bilter and
other cases that
yes,
preceded it. Yes.
Yes. But here the question is.
But you're saying here the company is.
Well, here the company knows full well what the status of that stock transfer form is.
Well, why? Hang on. Why do you assume that the company, as a corporate entity, has been informed by the sole director of their own wrongdoing in a way that means that the company can't say, wait a minute, this was never the act of the company?
The cases aren't in the bundle, and I must apologise that I hadn't anticipated, I don't think my learned friend had either, the argument going in this direction. But
maybe I've just misunderstood.
No, but the company must know, because I know I'm sounding rather like a cracked record, but you've got the company which is aware via Julie, because companies can only act by their directors. If a director, a sole director, signs a piece of paper purporting to deal with shares in the company and then instructs the company's accountant to alter the register of members on the back of a piece of paper that she's signed, it would be very difficult in my submission to see why the company wouldn't be on notice of the circumstances surrounding that piece of paper.
Okay.
Now,
I'm aware that I am way over my any fair amount of time.
Yeah.
You've got my skeleton.
We have got your skeleton.
And just to sum up then, it's a point I've made in the skeleton. From Mr. Justice Ricks in the Motis case.
Yes, we've got that at page 36.
You've got that. The point is that the court normally favours the victim of the fraud, not the innocent person who relies on the fraud. Who is the victim of the fraud here? It's Jeanette. She's had her shareholding taken away by, we say, a forgery, at the very least a transaction in breach of duty, and she should not have lost her right to shareholder. It's as simple as that. Unless I can assist further.
Yes.
And I apologise for going on too long, and I'm grateful for
No,
your
no, but
indulgence.
there were many interventions by us, so
Thank you.
yes, Mr. Doyle.
Lady, thank you.
I hope that although you're now delayed in starting, if needs be, we can go over, I think, a little.
Well,
But I hope really that the nature of the interventions will assist you in focusing your own submissions.
Well, they may well do, I think, because I think the fighting ground has been narrowed somewhat. And I think probably the risk of sounding sycophantic, we may have been assisted by the numerous questions raised, because it's, I think, assisted us in seeking to clarify what our respective cases are. I know that's certainly the case for myself. I'll deal with the grounds of appeal in the order that my learned friend dealt with them, unless you want me to do them in reverse order. I'm instructed just to make one, to get it out of the way, temporal point. There was a criticism made of the liquidators that they took some time to issue the application for directions. It took them about a year to issue it. We may or may not have to get into that, I suspect not. The response to that is that Jeanette Keegan did not issue an application for rectification for a far longer period after becoming aware of the position with the register. So I don't think it serves anybody's interests to try to criticise the other side on time. Can I deal with the first ground of appeal? And I'll go straight into it if I may, because I don't see the point in wasting time by revisiting documents that you've seen already.
No, we're familiar with them, and none of them are, they say what they say, they're none of them particularly complex.
I'm grateful. Could I ask you to turn up? I want to look at sections in the Act, sections 112, 113, those in the authority file are pages 5 and 6, together with 125 and 127. My submission is that there is a confusion in my learned friend's case and the way that he puts it when he talks about the register of members. Section 112 is not concerned with the register of members. Section 112 is the entire content of Chapter 1 of Part 8 of the Act. So that section occupies one distinct chapter, Chapter 1. And it does a job or serves a function completely different than Section 113 over the page, which is headed Register of Members.
Do you accept that to have a valid resolution of the members, or a valid special resolution at least, it's the members as defined by section 112 who have to have been summoned to the meeting or voted?
I do. I accept that.
Okay.
But where I draw a distinction is, if I may say, the unworkable distinction that's drawn between subscriber and member between those two subsections, and I'll explain why. In my submission, section 1121 does not permit or envisage a subscriber becoming a member without that individual being entered into the register of members. If it did, then the words "and must be entered as such in its register of members" would be meaningless.
Well, no, because at the instant that the company is incorporated, it has to have members. And the purpose of 112, the deeming provision, is because you can't agree with something that doesn't exist.
Yes.
So you are deemed to have agreed to become a member of the company, which by definition doesn't exist at the time, but on registration actually do become members without more, ipso facto, so that at the instant the company comes into existence, it has members. It is then necessary to register them as, put them actually on the register of members.
My Lord,
so there is a sequence. One, deemed to have agreed because you can't agree with anybody that doesn't exist. Two, on registration you become members such that the company has, from its very start, a necessary part of the company, which is membership. And then there's a sequential issue which the directors then have to write up the register of members to record that.
But Lord, if I may say, I couldn't agree more.
Okay.
I accept that entirely.
Yep.
There has to be, the members have to exist in order for the company to come into being. It has to have members.
Well, they become members on incorporation.
Yeah, quite.
So on registration, in fact, it says, but that's what it means.
That begs the question then, and what is meant by, or what is the function of the words "and must be entered as such in its register of members"? There must be a consequence if they're not registered. And my submission is the consequence is that the subscribers cannot be treated for the purposes of third parties dealing with the company as members unless they're entered in the register of members.
So wait a minute, the subscribers aren't members. Can you just give me that again?
I'm sorry. The subscribers, I accept that the subscribers are members on incorporation, but my submission is that there is a consequence of them not being registered in the register as such. And my submission is that they cannot be treated as a member by third parties if they are not registered in the register.
But what is the position then of a subscriber who, in accordance with section 112 subsection 1, is a member on the date of incorporation, and then for some reason, negligent, innocent, fraudulent, is not put on the register? That subsection 1 doesn't say that as a result they cease to be a member.
No, it doesn't. I accept that.
Yeah, but your argument is that there's got to be a consequence of failing to comply with the second part of the subsection.
Well,
and you say the consequence is that vis-a-vis third parties, if it's not on the register, because the register is a complete answer as to who the members are, that's that.
Otherwise, those words are just verbiage.
Yeah. I see what you're saying.
Who are third parties are liquidators of the company third parties for this purpose?
Any third party dealing with the company. But can I say this, my lord?
Well, okay, but liquidators are not third parties dealing with the company in the general scheme of things. They are statutory appointees to the company. They become the liquidators of the company.
Yeah, I accept that. I am answering the question when I make this point. There has to be somewhere that third parties can look to determine confidently who the shareholders, who the members of the company are. And the answer is they have to look at the register is where it's at for that purpose. So that the register by Chapter 8 of the
Does that mean, if, to take my lady's example, if a very ignorant company founder, to use a neutral expression, director, just simply doesn't put the subscribers onto the register of members by writing their names into the register of members, you're saying that that they're not members so far as the outside world are concerned? That when the liquidators get there, the liquidators say, well, we know they're the subscribers. The only thing that's gone wrong here is they haven't been written on the register of members. But we can't, can they or can they not be treated as members?
Well, it would depend, obviously, on the state of knowledge of the third party. But if the third party has no knowledge of the position, my submission is that the third party is entitled to rely on what is in the register of members.
Okay, is the director a third party for this purpose?
I don't think the director could be a third party without...
So the director who convened a meeting of the members would know, on that hypothesis, that they hadn't convened a valid meeting of all the members. this meeting that gave rise to the resolution was convened by the directors, wasn't it?
It was, but what my Lord's question is pregnant with is a sort of factual jump that's been made in the case so far as to what the knowledge on the part of that director is. And the problem with the case is we don't know. There's no findings of fact in this case.
But who was the only director at the time of the passing of the resolution to go into voluntary liquidation?
Jubilee's the only director. So I accept she's the individual but what we don't know is what Jubilee thinks has happened when she signed the stock transfer form. We know that she denies that it's a forgery, but we don't know what the problem is. It's all surmise as to what's going on in her mind. There's a purpose in me taking you to the subsections in this way, because I want to address you as to the difference or not that section 127 makes. So and if I can move on, I think I'll satisfy my Lord's question for the purpose of the way in which I'm putting it. Subsection 2, I accept, has two distinct conditions to it. So there's agreement to become a member, and then there's the requirement for registration. And there could be more than that. There could be a provision in the articles that had to be met also, but we don't need to get into that. If you look at section, so my submission is that what in fact subsections 1 and 2 amount to is something, if it's not a definition, it's something akin to a definition of what member means. Section 112 is not concerned with the constitution of the register of members.
Yeah.
But you'll see when you look at section 113 that 113 provides the mandatory requirements for what has to be included in the register. 113 being headed Register of Members. And I've counted them, I can take you to all of them, but there are 5 stipulations as to what has to be kept within the register. So 1132 entered in the register, 1133 entered in the register, 1134, second line, must show the amount and class of stock. Subsection 5, first line, must state, and in subsection 6, there must be entered in the register. So if you look at 112 as definition, if I can label it that way, of member, and 113 as mandatory requirements of register, and then turn off section 127, you see that the provision takes on, in my submission, a different light when viewed against that distinction. The register of members is prima facie evidence that's not conclusive of any matters which are directed or authorised to be inserted in the register of members. My submission is that does not have any application to section 112.
In fact, you're saying that's looking back to 113.
It does. That's exactly what it does. So the judge is right, therefore, and my learned friend is wrong to say that section 127 introduces a sort of rebuttable presumption by way of prima facie evidence in relation to section 112. Section 112 is binary. Somebody's either entered in the register or they're not, or rather they meet the requirements, the qualification requirements in 1 or 2. Can I try to address then the way in which, I should just say in our skeleton what we say is that if we're wrong about that, and I'm not sure in light of that submission, I'm not sure how section 127 could be read as providing a prima facie position in relation to 112 when you dissect its constituent parts in the way that I've sought to. But if we're wrong about it, what we say is that there wasn't any rebuttable there wasn't any material before the judge which would have rebutted the starting point, which disclosed that Julie was the sole member of the company. But it's paragraph 41 in our skeleton argument. The question then arises out of the submission that my learned friend makes, which is that if I've understood him correctly, what he says is Jeanette is a subscriber, and it's not possible to remove her status as a member by way of the second transfer of the 50% of the shares through the stock transfer form.
Can I just rewind for a second before you address that? As I understand your submission, you say that section 127 only looks back to section 113.
Well, it does. It may. I will look and say if I think it affects any of the other sections, but it's primarily section 113. But my point is, it's not 112.
Right, but section 113 starts 1. Every company must keep a register of its members.
Yes, that's right.
So why isn't prima facie the register? So why isn't the register prima facie evidence of who are the members of the company?
It is. That's my point. So what the judge is therefore able to do in this case, it's in paragraph 11 of the judgment. He says there's the finding of fact that there's a register of members, and Julie is the sole member. Yeah. He's entitled by reference to 127. He doesn't put it this way, but he gets to the same end result. He's entitled to say by reference to 113, the prima facie position is that she is entitled to all of the votes in the company as member.
Yeah. Okay. Prima facie.
Well, prima facie, yes, Lord, but the question you've got to ask is what's the material before the judge that would allow him to reach a contrary finding? You see, this is the problem.
What is said is Jeanette was a subscriber, ergo a member without registration. And I've just found that the stock transfer form by which she purports to have transferred the remaining 50 subscriber shares that she held was a nullity because she didn't sign it.
Well, I'm not sure he does say it's a nullity.
Okay, well, it didn't have effect because she didn't sign it.
No, but he's entitled. He's entitled as a finding of fact, following his own analysis, to treat the register as to treat the register as conclusive, and to conclude in the way that he does, in the absence of anything else. Can I show you in the judgment what he says about this? It's paragraphs 30 to 32.
Thank you.
Do you want to try 31 first?
Yes, I'm sorry. I said 30 to 32. So.
Oh, I'm sorry, 32. Sorry, 32 to 32. Sorry. 30 to 32, sorry.
31. Mr. Fennell submits nothing's to be gained from any further investigation. No suggestion Jeanette in any way authorised the forging of her signature, or that she has in some way acquiesced or is stopped from denying it's a forgery. I accept that submission. I can see no valid purpose served by any attempt at any further investigation of the facts of this case. And then he goes on to explain the position of the liquidators and the paucity of evidence from Darren, and limited evidence before the court suggests it's Darren who's effectively orchestrated the production and use of the share transfer form. Mr. Cochrane emphasises rightly that there is no court finding that there has been any forgery. So there's a vacuum evidentially, and the judge's response to that factual vacuum is to rely on what the register says. My learned friend introduced a submission which I need to address, which is the question of the subscriber whose shares are removed from her, and why it is that he says that my learned friend says that the subscriber shares should be taken into account in the calculation. The difficulty with that submission is that if it's followed logically, what it must mean is that the company is treated as having a greater level of share capital than it's got for voting purposes, than it has in reality. The register of members discloses 100 £1 shares. If the subscriber, the original subscriber, is treated as still being in the game for voting purposes, the effect of that, in my submission, would be that you would have to in some way ignore the voting rights attaching to the shares of part of the shares actually recorded in the register. And that has nothing to commend it. My submission is that the reason that the register is of paramount importance and has to be given the sort of paramount effect that the judge has given it is that, as my lordship put it, companies like this have to work in the real world, and there has to be a point of reference by which third parties are able to determine who the members of the company are.
But sorry, can I just pause? I mean, I'm not sure I quite followed it before we get on to that point. Are you saying that? I mean, I understand that there's been, quotes, no court finding there's been any forgery, and we've seen what Julie said, but if you go back to paragraph 20, and we've seen it, in the defence, Julie admits that it was she that signed the stock transfer form.
Yes.
So we have a stock transfer form which it is admitted was not signed by Jeanette.
Yes.
So we put aside the question of forgery and whether that sort of is something that is anything else. We just something which have a document which was just not signed by the person who was registered as the member in respect of the 50 subscriber share.
Well, I accept that, my lord, but in fairness, you have to look at what Julie actually says in paragraph 12D of the defence, which you've been shown.
But the point that's made against you is that Julie was the sole director of the company. She knew that she had signed the document. She was the one who procured that the register of members be altered in consequence of a stock transfer form which she knew had not been signed by Jeanette but which she had signed.
Yes, believing that was something she under the influence of Darren, believing that was something she was entitled to do. She says it's not a forgery. It's my signature. Perhaps we should just, instead of me.
Yes, but put the word forgery to the side for 1 second. It's just not a valid stock transfer form.
And, sorry, I'm not sure. I think it perhaps goes too far to say that she
maybe
believes.
It does. Maybe it does. I'm sorry.
I mean, it does say she'd said that it was an internal company document she was required to sign in order to resolve a dispute that had arisen between herself and the claimant.
Yes, I'm sorry. I'm not trying to put it beyond what it says.
You know,
It's well, and
I mean, it's pretty obvious to us all, I think, on the reading that she knew what she was doing was not appropriate. I'll put it as low as that.
Well, what may assist is my position is that our position is that I accept that what she had done had given rise to a transfer that was capable of being challenged and set aside. Right. That I don't think it would be reasonable or sensible to. I think that's a reasonable position to adopt in the circumstances of the case.
It allows everyone to make these submissions they want to make.
Yes, I think so.
All right.
Notwithstanding that, the difficulty is that for the judge to reach, the difficulty is the findings of fact that would be necessary for the judge to override what is contained in the register. That's the point I'm seeking to make.
Well, aren't you saying there are none?
That's
There never is, because we require certainty in the register for the third parties and all the things you've articulated.
Yes.
And there is a route called rectification, which can be retrospective, and so that's the way you ensure that people don't get away with fraud ultimately.
That's my point. What I was going to take it, but I can short circuit it.
No, please don't. I mean, this is my simplistic non-company
Well, no,
summary.
It's of assistance, because my submission is primarily is to say, although this may not now be an issue, there is no finding of fraud. That this is a case that does not involve fraud, and that matters because my learned friends' authorities rely on, and I don't seek to argue to the contrary, a share transfer document being a nullity if there's a forgery, which by its nature is fraudulent, operative in that transfer.
It is a document that's signed without authority to of no effect.
No, it's not.
As so far as the person who is said to have had, given the authority is concerned. So if A knows that the document they have in their hand has not been either signed by or authorised by B, why does that have some effect against B?
I approach it slightly differently, my lord, which is to say that when she signs the document, she gives an explanation of acting under the control of Darren. We know that.
Yeah.
But I don't accept that automatically renders the transfer a nullity from the outset.
But she knows the document she signs is the stock transfer form, which on its face purports to be that of Jeanette.
Yes.
Julie knows that it's not Jeanette signing it, and that she has no authority to sign it on behalf of Jeanette. Her explanation is
Yes.
she doesn't say, I thought I was authorised to sign this on behalf of Jeanette.
No, she says that she doesn't have authority.
On the contrary, she was saying Darren was putting pressure on her to sign it in order to do down Jeanette.
Yeah.
So, as against Jeanette, that document has no effect.
But my lord, this leads to a circular argument. The problem with that is that my concession was that I accept it gives rise to a transfer that is voidable. But the rectification proceedings are compromised and then come back before the court.
Yeah.
And if say for instance there hadn't been a compromise of the rectification proceedings and they'd run their course and Jeanette Keegan had obtained an order rectifying the register, the judge couldn't have come to the same conclusion. That's the point.
Yeah.
But that doesn't happen, and that's what I emphasise. And the judge is bound by the absence of those factual findings. Now, I accept that he says, well, this is what happens in the background, and it's easy enough in with the sort of acuity of looking back from here to say, well, come on, it must be obvious what had happened. But the approach of the court has to be based on factual findings. And the judge just doesn't have anything by which he can navigate in order to say, well, the register is overridden by what I know. And we know that because that's the conclusion he comes to. He says the register is the final word and that's it. And for the reasons I've sought to explain, he's right by reference to section 112 to do that. But I take my lord's point that he might be able to say with 113, well, the position may be different than 112.
But he does say, and repeat what's in the schedule to the tomline order, for example, at paragraph 25,
Yes.
the judgment, and he therefore records the first paragraph of the schedule that Julie accepts and acknowledges that she does not own the 50 shares. And so looks on the register as if she does. She accepts she definitely does not. So that's not forgery, and there's no finding of forgery. But he is in a position that it's accepted by the parties that the transfer was not a transfer.
Yeah, at the time of the judgment, that's right. But at the time of the resolution to appoint, the position's different. So he's looking at it after the event.
And you say, for those purposes, the liquidator is a third party.
That's my point, that the liquidator comes to it, they do their best, they don't have the register, they have to go on what's registered at Companies House. Mrs. Mayo explains this in her first statement. And they're entitled to rely on the register, and that is why, in my submission, the judge comes to the conclusion that he does, which is this may have happened subsequently by way of the proceedings, but at the time of the appointment, there was a valid appointment because none of this had been ventilated.
But the appointment is only. I understand that the difficulty liquidators face when they come to an appointment, but the appointment is only valid, surely, if it's valid as to bind the company, and in this case, the sole organ of the company was the body of shareholders.
Yes.
And the only person who purported to be the body of shareholders
was Julie.
And so, how can you get to a situation where, for example, the company and Julie would know or be bound to know that this was not valid because she knew she wasn't, or the sole shareholder. But the liquidators can say she was. It was valid.
The answer to that is that's what rectification exists for.
Yeah, well, I fully understand why you would say that the position of the liquidators would have to be taken into account or in some way addressed if an order for rectification was made, or if the dispute as to the validity of the resolution was resolved. But why can liquidators insist that they are validly appointed if, in fact, everybody involved in the appointment must be taken to know or did know that it wasn't valid?
Because I don't want to go around in circles with this, although I am, because the register is determinative and has to be given the sort of paramount importance it has, and the appointment is based on that. Otherwise, the problem is, the liquidators have to then get into a sort of train of inquiry into all of the possible dealings that may have been in the background. That's a completely unworkable outcome when one's dealing with a company in the way that office insolvency practitioners do. But I stand by my point that the judge was entitled, even taking account of section 127 allowing for a rebuttable presumption, the judge was entitled properly to reach the conclusion that he did, notwithstanding all that had passed between the parties because of the compromise that they'd reached between them. May I just turn my back for a moment?
Certainly.
I won't take your ladyship's and your lordship to it, but just for the purposes of footnote in that argument, I would ask that, if I may, that the court takes careful account of what she says in the defence as to what she was doing when she signed. My submission is there's no fraud, there isn't a forgery, but there is a question mark over the propriety of what she's done. It's not, in my submission, as clear cut as it might have been suggested to be, acting as she was under the control of Darren. She's not a lawyer, she's not an accountant.
Yes, but you sign a transfer form knowing you're not the person who is transferring, and that you have no authority on their behalf to do so. There we go.
Well, my ladyship, there's the short answer to that, and I don't want to get sidelined into this, is she's the sole director of the company, and she may say, well, as the sole director of the company, right or wrong, sole director of the company, I believe that I'm able to do this. What this presents is the fundamental difficulty is we don't have findings of fact on which to base this. That's the problem. And we don't have them because there was a decision made by the parties to the rectification proceedings to compromise. And as a consequence of that, the parties, as part of the deal, essentially chose...
Papered over this crack.
Well, yeah, they chose to forego findings of fact that may have been in their favour, but that's what happened. There's no way of manoeuvring around that. I'm not sure I can take the point very much further.
That's right.
As to the second round of appeal, I don't in any way seek to argue anything other than the Reuben case standing as authority for the proposition that a forged certificate is a nullity. And that's, if I may say, that's trite law. But I don't understand the relevance of that authority to this case. I can make my point shortly. There's simply no finding of fraud in this case. There's no factual. The judge, I've taken you to the passage. The judge makes the point. There haven't been any findings of fact as to fraud, and this court is not positioned well to reach conclusions as to facts in the absence of anything to that effect below, and in the absence of material that would allow for such a finding. And of course, when we talk about a forgery, by the nature of forgery, fraud is an inherent part of that. There's a passage in the Lovett authority that you've got in the authorities bundle, paragraph 95, where Mr. Justice Davis says all forgeries in their own way involve a fraud. That's perhaps self-evident. But in the absence of any findings of fact as to fraud or forgery, my learned friend's submissions, in my respectful submission, don't take him anywhere. And he's not able to found a case based on fraud or forgery. I'm not sure how much further your lordship have in me developing the second round of appeal, because it may be that it falls away in light of the first ground.
And what you've just said forms the basis for your respondent's notice, which is that the stock transfer form was not a nullity, because you say there's no factual finding of fraud.
That's
or
right.
Forgery. And then secondly, even, which is denied, if it was a nullity, you say the decision to put the company into liquidation was valid. points that you've been making don't go to that second paragraph.
No, they don't, and I'm not going to seek to advance that second paragraph.
Okay.
My junior,
But your point about no finding of fraud or forgery goes to the first one.
it does.
Okay, thank you.
My junior is not present, but I'll say no more than that. I'm not going to advance the second one. I don't know if I can take matters any further. Can I, again, just turn my back for a moment?
Have you got it? Richard?
I don't know if
Richard?
Would your ladyships and your lordship, I just wonder with the introduction of the, it's not a criticism, but perhaps the nature of the way these things happen, my learned friend's sort of additional point. I don't want to overload, neither of us want to overload you, but is there any scope for any written submissions that might
That's
assist?
exactly what we were just wondering.
Yes. With sort of on a very focused basis.
Just give us a moment. Hear, of course, what Mr. Pennell says in reply in a moment, but where we've got to at the moment is we think that when in due course we're obviously going to reserve our judgments, and when we go away and when we've thought through it and see where we've got to, if we feel that we require any further written submissions, we'll actually formulate something very precise so that you know precisely what we are asking you to do.
Very well, thank you, my lady.
Thank you very much indeed, Mr. Doyle. Anything in reply, Mr. Pennell?
Lady, very briefly, it's the nullity point. I'll be two minutes on it. We say that the stock transfer form was on any view a nullity. If it was forged, it's a nullity. Rubin is authority for that.
Yeah.
If it's a document that was created by mistake thinking it's something else, then it's not Jeanette's stock transfer form. It's not signed by her. She's not avowed it. And so as against her, it remains a nullity. But I indicated briefly to my learned friend while your ladyships and your lordship were discussing, I would certainly be very well keen to file any written submissions that might assist the court.
We're sorry, but we're sorry. But, I don't think actually a longer time estimate would have made any difference. I think it's simply the way that the very helpful submissions and the way the case has developed really, and it might lead to needing some written submissions rather than an absence of time.
Thank you. Just to be clear, that I understand that last point you've made, Mr. Fennell. You say, forget forgery for a second. If a person A signs a document knowing that they are not the person in whose name the document is written,
Yes.
then you're saying, as against that other person, B, the document has no effect.
Yes. If I sign somebody else, if I sign my name on a document with somebody else whose initials are S. Fennell, and I sign it thinking it's to do with something entirely different, which is Julie's case, how does my signature in any way bind that other person? It's got to be, in my submission, a nullity against that other person who bears the same surname and the same initial as me.
But signing it, knowing that it has actually to be signed by Simon Fennell.
Yes.
And knowing that you are not Simon Fennell.
Yes, exactly. Simon is not bound. I've done something which doesn't bind him. He doesn't know about it. As Jeanette didn't know about it.
And as I understand it, you say that must render anything which is done on the strength of it invalid, and that there's enough findings which overcome the prima facie status of the register.
Yes, that's correct.
And it goes without saying that I'm bound to disagree with that.
Of course you are.
For the very reason
Section 113, apart from anything else.
well, and which is why I asked respectfully if care could be taken in looking at what Julie actually says.
Well, I think that's
in a
one
different
of the
set of proceedings.
Mr. Law, I think that's one of the reasons, the way that has evolved during the currency of the argument, is one of the reasons that we may or may not come back asking for further written submissions, because certainly for my part, I'm very keen to go back and go through all the source material as well as the judgment, and including the witness statements, to be very clear in my mind precisely what everyone was saying.
My lady, quite. If I just may say, as the last word, it can be a real temptation sometimes in cases like this to say, well, come on, everybody knew what was going on, it's obvious. But that is a tempting road not to be gone down.
You're reminding us that as an appeal court, we're bound by the findings of fact. We're not going to make findings of fact.
Everything
So we cannot speculate.
Everything I say is prefaced with the greatest of respect.
But
Really?
Right. But sorry, just to be clear though, it's not just the findings of fact, though. It is the case that what is in paragraph 12D was signed with a statement of truth.
Yes, it was.
Yeah.
So that is evidence in the rectification proceedings.
It is, but the response to that is the same individual then considered herself able to pass a resolution that she did, the resolutions that she passed, in order to place the company into liquidation, which must raise a question as to what she actually believed her status to be. Because it would follow that if you take the view based on the paragraph 12, if you simply say, oh, well, she's just done it easily, knowing it's all wrong.
But you're taking us down the path we've got to avoid, because otherwise we start speculating into the realms of, or was this spite in the context of a bitter dispute, bitter divorce? I mean, we just can't go near any of that.
That's my whole point, which is there are cases which on appeal, of course, it's impossible to resolve in the way the parties might want them, because there's just not the factual grounding that allows for the conclusions that I say my learned friend asks for.
Well, that's your respondent's reply. You've had your appellant's reply.
I'm sorry.
No, not at all. It's very helpful. It's just that I've already said.
Mr. Fennell,
Yes,
do you
yes.
want to add something to that?
I think I've made my submissions clear, and I don't think anything further being assist. Thank you.
Well, I'm very grateful. Thank you very much. Well, I think as everyone present in court will appreciate, and I'm sure, this case throws up some interesting and difficult points which we obviously wish to consider between ourselves and ultimately to produce our draft judgments. I'm very conscious, I think, that your lay clients are probably in the back of the court who must have found the whole morning by turns bewildering and frustrating, but I'm confident that you and your instructing solicitor will explain to them that we are dealing with issues of law and not sentiments and emotion, no matter how strongly they may feel that.
I'm grateful, my lady.
We'll send out our drafts in the normal way for minor typographical and factual infelicities and not an opportunity to re-argue the case. We've already dealt with the fact that we may or may not ask for brief written submissions on any specific point that may crop up. Can I thank you all very much indeed for your very helpful submissions in this difficult case. Thank you.
Court rise available.